Mr. Vice President of this court, honorable members of this court, let me begin at the outset by profoundly appreciating how you patiently and at times tolerated us during these 2 days of our oral submission. So thank you very much. And I'm saying this with first-hand experience of what it means to be on that side of this court. Mr. Vice President, honorable justices, this case represents a troubling attempt to undermine the procedural integrity of this institution. It is also a moment of heightened responsibility. As the first state-to-state dispute brought before the court, this case carries profound implications for the procedural and substantive standards that will govern future proceedings of this nature. Any leniency or deviation from these standards risks setting a dangerous precedent, undermining the court's legitimacy and its role as a guardian of human and people's rights in Africa. As our arguments conclude, let me take you to the court's website, very beautifully created website, in a section entitled The African Court in Brief. There, the court emphasized that its authority is built upon its unwavering commitment to the core values, amongst which I quote, judicial independence and impartiality as between all litigants, end of quote. Let me also quote again, I quote again, fair and impartial application of the African Charter, end of quote, and other relevant human rights instruments. The trust that African states place in this court depends fundamentally on its adherence to these core values, as well as on insistence on rigorous compliance with its rules and established procedural norms. This trust is not a given. It's normally earned and maintained by ensuring that all parties are held to the same exact standards, regardless of their motivations or the nature of their claims, and by applying the law as it is and stands today, not as a party may wish it to be. As with other courts, the integrity of this court's process is what ensures its continued relevance and authority in resolution of disputes across the continent. Hence, to compromise on these principles would risk not only the erosion of that trust, but also the diminution of the court's stature within the broader framework of international justice. This cannot be allowed to stand. African states, peoples, and individuals deserve nothing less than the highest standards of international justice, upheld with fairness, rigor, and also integrity. The respondent has, in the last 2 days, demonstrated that this application is not merely procedurally defective, but also substantively baseless. It fails to meet the most fundamental requirements of jurisdiction and admissibility, representing a clear disregard for the foundational principles of international adjudication. The applicant's actions constitute an orchestrated misuse of these court's mechanisms, evidenced by its procedural irregularities, failure to exhaust local remedies, and reliance on duplicative claims filed before another forum. Such conduct not only undermines the integrity of this proceeding, but also risks setting a precedent that encourages frivolous and at times abusive litigation practices within this institution. In other words, the applicant's case is, at its core, a poorly constructed attempt to overwhelm this court with procedural irregularities and excessive claims in the hope that something may stick. This honorable court has the duty and indeed the opportunity to to reaffirm its commitment to rigorous procedural standards and the rule of law. We respectfully urge this court to dismiss this application in its entirety and to do so decisively, leaving no room for doubt that such tactics will find no quarter within these chambers. Finally, we respectfully remind the court as it retires to consider these preliminary objections that the court is considered to be bound by the application as it was filed, as matters stood as at 11th August 2023. It is telling in its oral submissions the applicant has heavily relied on matters which are alleged to have arisen since and after 11th August 2023. Any such subsequent matters are extraneous for the purposes of the court and should not, we submit, form part of its conclusion. Mr. Vice President, Honorable Justices, the Republic of Rwanda respectfully requests the court to adjudge and declare that A, the court has no jurisdiction to entertain the DRC's application because the matters contained therein fall outside the material and territorial jurisdiction of the court, and B, alternatively, and I stress the word alternatively, that the application is inadmissible for the following reasons. First, the application is incompatible with the Constitutive Act of the African Union. Second, the application is based primarily on news disseminated through the mass media. 3, the applicant has failed to exhaust local remedies. 4, the application deals with issues that have already been settled. 5, the applicant has failed to fulfill mandatory procedural conditions. And then finally, 6, the application is an abuse of process. Thank you very much for entertaining us today. Thank you.